Okay, so this is the President's Report 2020 for the Windermere Oaks Water Supply Corporation, presented by myself, Joe Gimenez, the President. All right, we're going to use just a standard corporate strengths, weaknesses, opportunities, and threats format for this presentation. I think that's a standard business presentation that fits the purposes that we need. I think that one of our biggest strengths, of course, is always George Burris, our water manager. This picture was of George with Tommy Collier, who is one of the head fellows at Corix Utilities. And we were on top of the Ridge Harbor clarifier back several months ago. And these two men are instrumental to keeping our corporation, our water facilities running. And I think that they just are instrumental and key to our continuing success. You know, last year, actually 2019, we dedicated our water treatment facility to George and named it the George Burris Water Treatment Facility. And we had a long list of reasons why we were going to do that. The top one was because he has kept our water and sewer plants running during many flooding events. And I thought that we should add flooding and freeze events, because as we know from our experience here in the last month, we were running during the freeze event of 2021. And I think that's a remarkable achievement, and many thanks go out to, should be extended to George and the crew. And it was there's no doubt that it was a historic winter outbreak. And I wanted to make record of the fact that, the National Weather Service and many others, of course, recognize the impact of that event on us. New York Times got in on the act, noting that, nearly 2/3 of residents were disrupted, leaving millions without drinkable water. We here in Windermere Oaks did not have that type of disruption. USA Today said that in Texas, water service for more than 12 million residents and more than 680 water systems were disrupted. 680 had to issue boil water notices, which we did also, but for a relatively short period of time. A lot of the effort goes back to the July 2019 decision that the board at that time made, including myself, Bill Ernest, and Mike Nelson, of course, with the guidance from George. And that was a multi-year decision on the part of the board. It had been discussed George says, for 15 years beforehand. And we made that decision on July of 2019. Now, a lot of people have never seen the pump and the generators in action, and I thought I would go ahead and share for some of our members the generator test that ran in February of 2015. So I'm going to hit this button. So this was February 25th, 2015.
Well, let me back up. When you are ready, or what?
What are you missing out of?
Yeah.
Okay, so that was the generator running its first time with the pumps, and we can say that it turned on. I'm gonna turn that off. But the pump isn't the only thing that's worked well. We have had great water quality for many years now. And in 2019, it was no different. Um, 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 on all of the different measures that the TCEQ tests our water, we were perfect. This N indicates no violation, and the report it's a lengthy report. These are some of the other measures. Again, no violations. The 5 or 6 pages of report shows no violations anywhere. If our members would like, they can understand that we've had 4 years of perfect results. The results are available for everybody on our website at the webmail, the URL there on the screen. We had some other tests of our water system. This was one from December of 2020, and the TCEQ came out and took a log data test of our volume, of our pressure. And the note that George got back was the log demonstrates that there were no points during the recording period where the pressure fell below the minimum required. The TCEQ also, in January of this year, came out and did another inspection of our wastewater plant, and they found no violations are being alleged as a result of the investigation. So another factor came into play here in 2021 that was at work in 2020. And all of these decisions kind of link over time. The board on October 9, 2019 of myself, Bill, Dorothy, and Mike voted to approve a LCRA grant application. The grant was put together by Dorothy with George, and it was for a $48,000 project. We got some news out of it, and this is the news that we got out in 2020. It was the LCRA grant to Windermere Oaks will help the community save about 4 million gallons of water per year. The $14,000 cost share grant will go toward the $48,000 project. We just had to commit $34,000 so that the LCRA would match us with $14,000. In my opinion, it was a very good investment on many reasons. First of all, toward the end of the year last year in December 2020, we noticed the gallons lost decreased significantly from the previous year. And I think that this may have been high for that year, but I just used the year-end number in 2020, where in December 2020, the company produced 1.8 million gallons of water and only lost 16,700. Some of that, a lot of that was due to many factors. I think George and his crew have been working on improving and stopping leaks around the system, all for the last year. And with that conservation project, it really kicked in, and will be kicking in more over time with another project that's slated to kick in this year. Another strength in 2020 was the application and approval for the CoBank loan. We received the word on that loan on June 11th, 2020, where John DeLuca of CoBank wrote to me, Joe, I am pleased to let you know that CoBank has approved the loans we've been discussing. It wasn't an easy task, as the lawsuit and rate challenge are clouding the waters and create some uncertainty. Thanks to your efforts to explain the situation and steps the system has taken to address, we were able to get comfort in possible outcomes. The loan closed in October, and we got very good rates for the monies that we have now borrowed. This loan is for the one part was for $230,000. Actually, it was 200 or so at the time, because we were able to use that money to pay off a balloon note. We were able to pay off a balloon note that was coming due, I guess, this year at First United Bank for 4.75%. And the interest rate that we were able to get was 3.75%. And we probably will get about a 0.5% return every year that we have the loan with CoBank. We also received $150,000 at closing in October. And we also were approved for $300,000 up to 12 months through October of this year for purposes of buying and installing that clarifier that we've been talking about. This brings me to the next subject, the clarifier. We have a very old clarifier. It's small. This is the old clarifiers at Ridge Harbor. Ridge Harbor doesn't have nearly as many people as we do. They're just on the cusp, I think, of getting to 250. And they are planning for growth there at Ridge Harbor. And a few years ago, in 2017, they installed this 30-foot clarifier to keep up with their projected demand in the future. This is the top of the Ridge Harbor clarifier. This is our clarifier. And by comparison, you can see how small it is compared to the Ridge Harbor clarifier. So that just means that there's much less water that's getting clarified at any particular time. And I believe from my conversation with George, it takes about 2 hours for water to get into that tank and do its thing to get clear to move on to the next step of the process. We need a bigger clarifier. We need one that's easier to clean and maintain. This one's old. It's 35 to 40 years old, from what I understand from George, and you can see the rust and the growth and broken pipes and things. And from what I understand, it wasn't really intended to even be a clarifier, but it's been modified to that. So we are in a financial position now to go ahead and get the clarifier. We believe that George has an engineering plan at the TCEQ that's available for approval. We have financing secured. Hopefully it won't be too much more than the $300,000 that we've allotted. And if it is, we'll have to figure some things out. But George is looking at June, July installation. Of course, we're still getting some proposals, and George told me earlier that he's meeting with a fellow tomorrow morning, actually, for a final estimate. So things are moving along good on that front. If I had one weakness to talk about tonight, it's our key man consideration. So much of our system is dependent upon the great work that George does so well every single day. And I believe that this is always something that our board should be asking about, just in case George decides to retire, something happens to him, there's a company comes in and buys him for 10 times the money we're offering because he can manage multiple systems. We need to always be considerate of the fact that George is a very important part of the success of this organization, the most important part of the success of this organization. I think that we have it covered with some different options that George has told me about in the past. So we just need to stay on top of that as we move along. Another weakness that I think is evident is what was contained in this letter. And this letter said, in particular, it wasn't an easy task to approve the loan, as the lawsuit and rate challenge are clouding the waters and create some uncertainty. This was a challenge to our corporation to get the financing it needed to get that clarifier. And it's a real shame that we're in that situation. And we're going to talk a little bit more about the threats of the lawsuits and rate challenge a little bit later in this presentation. But I think that it is certainly recognized as a challenge and weakness of our corporation by people external to our corporation. So let's look at opportunities now. This is the land. This is some land that we have available to us in the shaded box on the left side. This is land that the water company owns. And earlier this year, there's about 7 acres of land. The company, the board actually, in August of 2020, set up a committee to market and sell the land. And the company was going to do that to use the sale proceeds to, rebuild our financial reserves, support the legal fees and legal challenges that we've been incurring, and ultimately to lower monthly water bills for customers. But we had a problem. That land is tied up now in the lawsuit where we can't sell this land. We were notified in November, I believe, this is the date stamp up here, November 10th, that the plaintiffs have put that land under a lis pendens, which prevents the water company from taking those actions. Another opportunity. We have right now dispersant fields, which take water from our wastewater treatment plant and spray them on ground, on the grass, to let them absorb into the water and start getting filtered back into the water systems. In this chart, we see 1, 2, and 3. 1 is the Spicewood Airport Pilots Association grass runway. That is about 3 acres of land that we have contracted with the Spicewood Airport Pilots Association to provide affluent water that's been treated to a pretty high degree, but not to potable standards. And they are, as everybody remembers from 2019, we are in agreement with them to provide that water free of charge to them for 10 years because it benefits our overall system and the amount of dispersant fields we have available to us. Field number 2 is the current dispersant field that you see being watered every day when you drive down Exeter. Dispersant field number 3 is, well, it doesn't exist just yet, but it's there and it's available to us. And there's some options that we have going forward to build that out. Part of the grant, part of the loan money can be used for us to put in a dispersant field in there. I think we allotted and asked for about $80,000 to put that field in around it in this area. However, the question is, are we going to benefit more from our relationship with Corix? George and Corix are in talks about that field. Corix and other utility companies around the area need additional expansion or dispersant fields. So we'll see if there might be some sort of arrangement that's worked out that might lessen our projected $80,000 outlay. It's a good opportunity. We'll see. Now let's get to the threats to our system. This, of course, is not a pleasant part of not a pleasant part of this presentation, but I'm going to be as honest. I'm going to be absolutely honest and call it like I think the facts line up. Let's go back a little ways to 2018. We had this lawsuit filed against the Water Corporation. It was case 47531. It was Toma Integrity, which was made up of Renee French, Bruce Sorgan, and Richard Dial, and originally a member, Danny Flunker, and then I think he might have bowed out. But this was the one of the first cases, or the first case against us in recent years. The trial court decided against Toma. This was the judge's ruling, the final judgment. And that final judgment continues onto the second page. And it says, the court hereby renders final judgment for plaintiffs that defendant Windermere Oaks Water Supply violated Texas Government Code Section 551041 and the WOWSC board actions in December 19, 2015 and February 22, 2016, as alleged by plaintiffs. All other prayers for relief in this case are denied. So that was the decision, that everything else that they asked for was denied. I don't think many people in this neighborhood are very new, and they have never seen what the agenda item issue was all about. And so I thought it would be good just to show everybody that the agenda, one of the agendas that was referenced in the judgment. And you can see down here on number 5 that it says executive session to discuss real estate, personnel, or legal matters. This is a recent agenda from one of our board meetings. And we can see that the board may go into executive session under Texas Government Code 551071, consultation with attorney, to discuss item 10, which were legal matters. We included an item number 11, consideration and possible action on items discussed in executive session. That item was not present in this agenda, and it was the reason for the lawsuit. This is just the appeals court that decided that the trial court's decision was correct, and the appeals court affirmed the judgment of the trial court. The appellees, the plaintiffs, took the case to the Supreme Court, and on February 14th of 2020, the Supreme Court said that the motions for rehearing of the following petitions for review are denied. And in this case, it was Toma Integrity. So on February 14th, that case of 2020, that case was ended. That was 47531. It lasted from April 2018 to February 2020. Estimated total cost was $80,000 for filings, board updates, everything that had to do with proceeding and succeeding on that case. And that's an estimate. That's just an estimate. It's really difficult to piece together so many things over time and exactly what the attorneys were doing, but for individual cases. But that's a pretty good estimate about the cost to our system. Personally, I have concerns about the allegations in the lawsuit, which claim that no one knew about the sale, the marketing and sale. And these are minutes from the Spicewood Pilots Association annual membership meeting. And these were in May of 2015. And the minutes from that board meeting say, on the topic of the WOWSC, the property that they own adjacent to the hangar community is now being marketed for sale. So we've learned through discovery that the plaintiffs were in attendance at that meeting, and people knew about what was going on with the water company at that time. Last year, I described the next set of slides as a nuclear bomb that was lodged on our water corporation. I'm going to tell a little bit more about that now. In 2019, we were in 2018, I should say, a new case started. Now, remember that in 2018, they'd also started 47531, and this was a case 48292 that was filed by Double F Hanger Operations, Lawrence French, Patricia Flunker, and Mark A. McDonald versus Friendship Homes and Hangers in Burnett County Commissioners Court. At the time, the water company was not a named party to that lawsuit. But things changed in May of 2019 when the plaintiffs in the 47531 intervened. Actually, Renee French was in original plaintiff to 48292, and he was joined at that time by John Richard Dial, Stuart Bruce Sorgan, as representatives for Winnebago Supply Corporation versus the corporation, Friendship Homes and Hangers, and 5 board members. This is Public Information Act request from 2019. And we can tell from the timestamps of when those Public Information Act requests came in that many of them were from the plaintiffs: Renee French, Danny Flunker, Dick Dial, Renee French, Bruce Sorgan, all before that May 2019 filing of 48292. In my opinion, they were using the PIA request to get information for their filing. This case is now, this looks like a duplicate slide, so my apologies. That's a duplicate as well. All right, so we're still in 2019. In 2019, October 2019, at the same time that we were voting on the LCRA grant, there was a petition for removal for the board for me. Quite honestly, it was me, and that was another legal challenge. We were also working on a mediated settlement with the company that bought the land from the corporation for an October 26th meeting. That meeting was held on October 26th on a Saturday for all of our members to attend, and we had a 4-hour meeting that was very constructive. We got a lot of community input, and we thought that it was very important to have that meeting so that our members would understand that we wanted to operate as transparently as possible in all matters regarding these lawsuits and land sales. Well, little did we know that that would not be acceptable to the plaintiffs in 48292, because they then, a few weeks later, turned around and added myself, David Bertino, Mike Nelson, Dorothy Taylor, and Norm Morse to the lawsuit. So they expanded their lawsuit to cover additional directors. I wanted the members to take a close look at the invoices from October of 2019. And we're not going to do this for every month, but I just thought it would be instructive to look at October 2019. And the reason is because this is going to play into future discussion about the rate case. On this page, we can see all types of activities that were occurring. We had PIA requests. If you start at the top on October 1st, there was a PIA request from Danny Flunker. There were other PIA requests that were coming in. We were working on an agenda for the October 26th meeting. We had some appeals that were at the Attorney General's office. We were working on how to structure the board meeting and mediation. So there were many things that were actually the mediation, I think, had already occurred, but we were working on many things. And this was in early October, and we can see here in the middle part that all of a sudden there was the recall petition that was then added to the workload of our attorneys. This is more of the invoice from October 2019. And this is more of the invoice from 2019 with a total of $15,700. But they were working every single day on some issue of the water company. And October 26th, they were here in Windermere Oaks at a meeting to help us with issues that were brought up in 47531. So just to summarize, in 2019, our legal costs were $166,000 and a little bit more, but that's close enough. So let's get to 2020 and see how all of this rolls into what happened in 2020 and where we are now. We in February of 2020, down at the bottom, considered a rate increase to help us pay for the bills that were coming in from the attorneys for November and December. And we'd gotten wind of what their amounts were in January, and we said we are absolutely going to have to get a rate increase to keep up with the rate of legal requirements from our members and the lawsuits. It was a responsible move on our part because otherwise our company could have become insolvent, as we'll see. In good old Windermere Oaks fashion, we then received a complaint or a petition that was filed with the Public Utility Commission of Texas by, I don't know, 60 members, something like that, who filed a legal, this is a legal petition which has significant impacts on water systems. Many people have never seen what's involved with a petition hearing, a rate case hearing. But in this case, I wanted to show everybody the technical and legal issues that are brought up, maybe not so much by the ratepayers themselves, but also by the staff who has greater familiarity with these issues. So this is page 1 of the issues that would be addressed. This is page 2. This is page 3. And these are all the issues that we are asking legal counsel for help in justifying the rates that were increased in February of 2020. This is a summary of what we have been charged by our law firm for the rate case. Some of these charges come into 2021, and some of the activity varies from month to month depending on what the filings were. I'm gonna make a comment about the 1022 billing of $68,000. At the time, there were issues regarding the legal invoices for the rate case. The ratepayer representatives think that our legal fees were not reasonable in 2019, and that's one of their contentions for the rate case. Part of that, of course, was the defense of our right, or the company's right, to have privileged client information protected from Public Information Act requests. And so all of that got tied up in the in this month, in October, because it was apparent to us that the the person who had filed the PIA request, Danny Flunker, was trying to get these invoices through the discovery process in the PUC case. And so there was a lot of legal issues that were involved, especially because the 48292 case was ongoing. And the reason for our cloaking, our desire to privilege those documents, was because of the case that was ongoing in 48292. So I've said a lot there, but it just involves the fact that once you're in litigation, issues can get very sticky and very expensive, so that you're not broadcasting what you're doing to the other side, and they want to see it. And that was the case right here. So let's recap a little bit. In 2019, we had legal fees of $166,000. That caused us in February to have a $65 per month rate increase. Then in 2020, a rate case was filed, and we've already spent through March of this year $148,000 on just that case alone. This case is projected to last through July of 2021, so we're going to see more legal expenses from that case. Excuse me for a minute, I'm trying to manage some things that are coming on the Zoom call, so bear with me. All right. So let's go back and realize that where we are right now with regards to 48292. Where we are is that we have a motion for summary judgment in the court, which we put in on November 4th of 2020. That is our legal desire to ask the court to end some of these matters for most of the directors. Of course, when we filed that, we knew that the plaintiffs would desire to have additional discovery done in the form of depositions. And since November, we have had, I'm not even sure of how many, at least 6, maybe 8 depositions that have occurred in those ensuing months. And our last one was, I believe, in February for Mike as the corporate representative for the corporation. Here are some others that were either conducted or possibly delayed. We had numerous delays. You can tell that this is in February, and our motion for summary judgment was put in November. So there have been months of delays that have occurred around this process. Now, I mention all of that just to say that those are all legal costs that we were incurring in 2020. These again are legal costs that we were incurring in 2020 as well, which were the Information Act request. Information Act requests, not all of those are referred to the attorneys, or they are at least scheduled with the attorneys, but they sometimes are, sometimes we do ask for advice on certain elements of requests as to whether they can be released or need to be redacted or what have you. And this is just a summary of the fact that we did have more Public Information Act requests in 2020, which added to our legal fees. To look at our legal fees in 2020, I wanted to pull up this little chart that shows what our legal fee expense rate has been growing at, and why we had to increase rates in 2020. Our legal fees were very modest, low in 2017. When that first lawsuit came up in 47531, the firm spent $37,000. In 2019, it spent, probably another $50,000 on $40,000 on that appeal. And then we had the other lawsuit come in. And we also had the petitions, we had the PIA requests, etc. And then we just got through discussing all of the different things that we have been paying for in 2020, the PIA requests, the 48292 case, some of the 47531 case, and the PUC case. Oh, and we also had a petition drive that I'm not going to, to go into and didn't address in this presentation, but even that costs additional legal fees. So let's do a quick summary here. 2020 legal fees. The amount paid in 2020 was $240,000. The amount of outstanding legal debt that we know of is $275,000. We do anticipate insurance coverage for the directors and officers of in the lawsuit. I want to talk about the fact that I said that that lawsuit 48292 was a nuclear bomb on our corporation. The way that it was structured between the corporation and the directors required separate legal representation for the different groups. And it could even have required individual representation of the current and former directors. The good news is right now we think that we have submitted to the insurance company a number of at $218,000, which we believe they should cover. And we think that that is going to grow once they address the coverage issues. And that will help us with some of these outstanding bills. When we talk about threats to the neighborhood, I find it difficult on many levels that the people who are, looks like there's a duplicate sign in here, that the people who are suing the company, in this case we have Richard Dial putting up a sign somewhere at the airport, it looks like, claiming that the candidates that he supports will stop the lawsuits. There's one person or three people at least in that lawsuit that can stop the lawsuits, and that's Mr. Dial, Mr. French, and Mr. Sorgan. And to the extent that even Ms. Fuller was involved in the rate case, the person who started the lawsuit against us, she can stop it by withdrawing. I wanted to bring up the other result of all of this, and that is the fact that right now in the community, as it was expressed at the annual meeting in 2020 by Patty Flunker, that all of the politics around this might end if we just sell the corporation to an investor-owned utility. And on the left side, we see an email that was discussed between Stephen Donahoe and Patricia Flunker on February 18th. And this was in anticipation of a February 29th event that they organized and had at the Pavilion for Aqua Texas to give our members the benefits, suggest the benefits of selling to an investor-owned utility. Patty Flunker and Josie then also included a question on their survey to members that they issued in August. Would you attend a town hall meeting to find out more about our water supply corporation becoming a private utility? And by that, investor owned, no more boards, elections, and politics. Here's the letter that was sent to people who submitted their responses. I'm not going to read every word of it, but I do want to bring out one particular part of what was said in that. Based on the results, it is apparent that most customers and members would like to get more information about becoming an investor-owned utility. Moving forward, we plan on organizing a town hall meeting for this purpose, and we'll update you with possible future dates. This was at the bottom of the email that we just looked at. Our board in September asked NewGen Strategies to help us evaluate our financial situation at our corporation. And the information was that we have done very well given the considerations of the lawsuits that have been filed against the corporation. And I want to point out, we asked NewGen to address the issue of becoming an investor-owned utility. Here's what they said. First, an IOU's return on investment includes profit that a not-for-profit entity does not require. Second, the IOU must pay taxes, property, sales, income taxes, that a not-for-profit entity does not pay. Thus, the IOU must charge, for the IOU to charge same or similar rates, it has to operate more efficiently. We're very efficient as we are right now. And third, the board that is elected by customers, our board is elected by customers, but the customers of IOUs must rely on the Public Utility Commission to ensure that rates, policies, and decisions are just, reasonable, and in the public interest of all ratepayers. And guess how they do that? They do that through a ratepayer protest process that costs the corporation a lot of money, that then the corporation puts back onto the ratepayers. In my opinion, I don't think it's feasible or correct or the right move for us to become an investor-owned utility. My final couple of slides here is, this is our profit. This is our profit and loss budget performance from 2020. And you can see that despite the challenges, I want to go through this budget. Over here on the right side is the annual budget. That's just our projections. And over here on the left column, close to these items, is the actual. And in 2020, our actual was, some positive numbers. At the end of the day, we had net income of about $4,000. Now, this number over here, the $142,000 loss, that is what would have occurred had we not increased rates that created revenue, additional revenue of $16,000 a month to keep us solvent. If we had been burning through money at, $12,000 a month, which was what this reflects, our financial situation would be very poor right now and would be very limiting to our needs for growth and our needs to keep our corporation safe, clean, keep providing safe, clean water for all our residents. So I think with that, I'm going to conclude my report for 2020. And I hope that it was what our board members expect for our members at the annual meeting in a couple weeks, or less than a couple weeks. If you have any comments or questions, I sure would like to entertain those now.
Joe, I would like to make just one small comment.
Okay, good.
When you talked about the sale of the property, you said that funds could be used to reduce the legal fees. And that's actually against the recommendations from our financial recommendations, because legal fees are considered an ongoing expense and should be paid for by current member fees and not through a loan or things of that nature.
Or sale proceeds?
Yeah, the sale proceeds probably should not be used for going towards legal fees.
Okay.
I mean, some of the sale proceeds from future sale of airport property, to me, go to address the infrastructure clarifier, that kind of stuff.
Yes.
And I think that's what I indicated to John DeLuca in terms of supporting our reserves.
But you made a comment during your presentation.
You're absolutely right, and I'll take that out.
And
Yeah.
that's the point I wanted to correct, was the point you made in the presentation.
I will take that out. Thank you. Mike, did you have any comments or observations?
I thought it was pretty thorough, and all in all, I thought it was good.
It probably went a little too long for my preference, but I think there's been a lot there. And since there seems to be so much confusion in the neighborhood, I think that it was appropriate. And as I stated, I do not think that our interests lie in selling to an investor-owned utility. I'll relate to you one.
So,
Go ahead.
one other thing during your presentation, I think it's important to mention that in terms of the rate analysis, the board approved a rate based on the rate analysis that was done by Texas Rural Water Association. You know, they provide that service to us for free to do the rate analysis. And I think it's important for people to know it's not just the board going, oh, let's, throw a dart. It's they take the cost involved and they come up with the number to tell us what our rate could be based on our expenses.
Great comment. I can roll that into that part of the conversation. And, that is what Mike and I have been working with the PUC on, is how to correct our TRWA sheet so that, if this ever comes up again for, any future board, we can have an unassailable rate, sheet that.
Well, I think that's what we relied on for the, previous before this rate increase. It was what we relied on. We used their analysis for rate decisions. So.
Right.